Good morning, everyone. Can I just begin by reminding you that reporting restrictions as in place on Wednesday continue to apply to this application. Now, Ms. Felix, can I suggest you come and address me from the bench here? Thank you. Yes.
Well, sir, may I begin with sincere apologies on behalf of the CPS for the lateness of this application and the difficulties that we know have arisen as a result of that application being at the time it is. Can I set it out in this way? And I don't want to engage in trying to attribute blame anywhere. I don't think it helps you, sir, in the task that we're inviting you to address today. But as soon as those instructing me became aware of the very real difficulty, which was on Tuesday, steps were immediately taken to try and deal with the issue. But that is why, as I put it, we are where we are.
Yeah, well, some monitoring of the witness arrangements seems to have been going on, because looking at paragraph 8 of your application, you say that you didn't know when they were going to give evidence, but it was understood that the evidence was to be given after the trial had been completed. So someone seems to have been showing some interest in these things, although possibly not sufficient interest.
Yes, well, I can tell you where that comes about, because I had a conference with the officers about 2 weeks ago, at which point I learned that they were to be giving evidence before this inquiry. But I walked away from that, perhaps not having asked enough questions, but I walked away from that with the firm understanding that their evidence was to be given after our trial. And so I didn't trouble myself at that point. So that's where that comes from.
Yeah, all right, thank you.
Can I turn to the application?
Yes.
And you have, I hope, my written document.
Yes, now, before you go any further, I've received this morning observations, submissions from a range of other parties. Have you seen them?
I have very briefly seen them.
Yes, you haven't had much time to digest them. But I suspect that much of what they say, shall I put it like that, doesn't come as any surprise.
No, it doesn't.
Right, good.
It doesn't.
All right, thank you.
Much of what I have to say is in the written submissions and application, but it may be that I can assist to some degree with headlining, if you like, the 4 topics that I seek to address you upon, and then to go to each of those by reference to the written document that you have and just add a little to them, if I may. The application itself is addressed at paragraph 1 of the document that I've submitted, and it seeks 2 alternative courses. One is the restriction order in respect of the evidence, and the other is to invite you, sir, to change the order of proceedings that's already been timetabled, and I have no doubt whatsoever of the tremendous time and effort that has gone into ensuring that people are able to give evidence at the time that they do. But to invite you to move these 2 witnesses to the conclusion of the criminal trial, and what I mean by conclusion is the return of verdicts by the
whenever
jury.
that may be.
My anticipation is the witness order at the moment is that the evidence will complete by Wednesday, and the jury summing up speeches and the jury out on Wednesday. That's what I see happening.
That's on the assumption you get a clean start on Monday morning.
We're fixed on Monday morning.
Right, good.
My witness timetable anticipates that at 10 o'clock any issues, legal issues as there are, will be dealt with. I anticipate opening the case by about 11 o'clock in the morning. I don't anticipate being more than about half an hour opening the case and then to begin calling witnesses.
Yeah.
So I expect the Crown's case to close by Tuesday lunchtime. I accept, of course, the vagaries of a criminal trial mean that...
Well, you never quite
things,
know what happens
No.
in litigation of any sort, do you? And sometimes
And
things
that's all-
run to plan and sometimes they don't.
Yes, and all the more so in the context of a criminal trial. Of the alternatives that I've advanced there at paragraph 1, for reasons that I'll come to, it's our submission that when you come to balance the competing interests of ensuring that this inquiry progresses appropriately to its conclusion against the need for openness, which I know you are particularly keen to ensure, and the public interest in maintaining the administration of justice, which is what I say is at risk here, then the balance falls in favour of delaying evidence at this inquiry. If you are against me on that, and of course I have to
When you say the
recognise that-
balance falls against, well, in favour of delaying the evidence, do you mean that I should make a restriction order?
No. When you come to consider, the restriction order obviously will restrict the press. So, and there must be a degree of openness for them, and they're right there, as well as others. And when you come to look at that openness, as well as maintaining the administration of justice, and you balance that against the difficulties that will be caused if these witnesses are put back, we say that the balance falls in favour of the
Right.
difficulties.
Yes.
If you're against me on that, then we submit the proportionate response is to make a limited restriction order as to publication of that evidence before this inquiry. And I say limited to the extent that there should not be any publication until the verdicts from the jury. And we submit that that is a proportionate response to the substantial risk. So that is the application.
So what is your principal application? I have to say that the way I'd read your written document, your primary submission was for a restriction order.
I know.
And failing that I should direct that
No.
their evidence be deferred.
No, it seems, I'm sorry, you'll appreciate that there's some degree of rush trying to get this document together. And I'm not, yes, and that's our fault, I recognise that. When one comes to really look at it and you're balancing restricting public access and balancing how else the aim can be achieved, then in my submission the proper course is to first seek to put the witnesses off. Can I turn to the background?
But I mean, are we at IDEM to this extent that you recognise that at root, however you get to this question, it involves a balance between the need for openness in the inquiry's proceedings and the public interest in the inquiry's proceedings being fully open and the public interest in the administration of justice, in this case, the trial at Isleworth. Balancing those competing considerations, is that right?
Yes, and how best that can be achieved.
All right.
And so it's my submission that both of those can be achieved with a degree of delay.
But they both involve some degree of assessment of the risk of prejudice to the trial,
Yes.
which might be a good place at which to start.
Which is where I'm turning
Right.
now. Paragraph 4 in the document that I've submitted sets out really in a nutshell what the criminal trial relates to. And unless you wish me to go any further than
No,
that.
I have read this, but no, there's no need to go into that.
No. The evidence and the relevance of the evidence is at paragraphs 5 to 7.
You could help me on one thing, though.
Yes.
I can understand, at least I think I understand the way it's put in relation to Mrs. Wahhabi and Mr. Gomez. I'm not sure I understand quite so clearly how reading the evidence of Mr. Chebuini comes into the same category?
It's the reporting of that evidence, it's the extent to which it is reported widely.
Well, doesn't that depend
Here,
on what he...
I have to say I haven't seen the evidence
Well,
of
then,
Zachabuni.
if you don't know what he's going to say, he's not going to appear giving his evidence, because I think what's envisaged for him is that his statement will be formally put into the record and parts of it may be read, not necessarily the whole of it. Now, unless you know what he's going to say in his statement, how can you possibly suggest that reading out any part of it could have some prejudicial effect?
I'm only able to discern from the evidence of Hanam Wahabi, whose statements to this inquiry have been given to us on a confidential basis, describes precisely what he did on that night.
Well, maybe she does. As I understand it, the basis of your application is not what she may actually say in evidence and thereby affect the jury's view of things, but how she will appear as a witness, or may appear as a witness.
It's not just how she may appear, it's the nature of her evidence and how that's likely to be reported in the press.
Well, we've got two different things at work here, haven't we? I mean, in most cases, I would have thought, these sort of applications are put on the basis that the witness will say something which may be relevant to the issues in the trial, that what he or she says will be reported and read by the jury and improperly taken into account as if it were part of the evidence in the trial. Now, that's a perfectly understandable way of putting it, and it depends on what the witness actually says. It strikes me that it's rather different if the argument is, and this is what I'd understood it to be, partly from what Miss Clark said to me on Wednesday and partly from what you've written here, it's not the content of her evidence that troubles you, it's her appearance on the live stream, which may give members of the jury who see it, or indeed members of the jury who read press comment on it, the impression that she's a reliable witness, and thereby make it more difficult for the defendant to undermine her credibility.
It is in part that, but it is also the likely sympathy that's going to be generated. It's
Well, sympathy for her. I'm having difficulty with this one because I don't at the moment understand what sympathy for her plight has to do with how she, either with what she says or how she'll be regarded in her capacity as a witness.
I've got to be very careful about what I say because I know the defendant's case to be what it is. The issue in the case, he claims, as it is revealed in the indictment, that he lived at the address and that he was related to this family. That is plainly disputed by the evidence the Crown seeks to call.
Of course.
And so there is a central issue that this jury will have to determine as to who is telling the truth about that.
Mm-hmm.
I know what my case is. That doesn't mean to say that the defendant isn't entitled to advance his, nor to invite the jury to reach a conclusion about it. So there is polar opposites between these witnesses and the defendant, my case and the defendant. The jury are going to have to assess the evidence of the defendant as well as the evidence of the two witnesses who give evidence before them. In doing that, my concern is that they, and I accept the judge will direct them, that they must try this case on the evidence. That is the usual direction. The concern is that if there is widespread reporting and publication of what is, and I mean no discourtesy, and I know that there is some criticism in some of the documents that have been placed before you to Ms. Wahabi or to Mr. Gomez, nor do I seek to belittle the significance and importance of what they do say in those statements. we are concerned that when the jury come to weigh the evidence of both those, that if there has been widespread, very dramatic, sympathetic coverage of that evidence from this inquiry, that may, and there we say there's a substantial risk that it may colour their approach to assessing not only the witness's evidence, but significantly in assessing the defendant's evidence. And we say we are concerned about a risk of prejudice against him.
All right.
So it's not just that they will say she's brilliant, she's very credible. It's taking it all into account in the round.
All right.
So I don't know if I can assist any further on that.
Well, I think I understand more clearly, or a little more clearly, how it's put anyway. Thank you.
Thank you. The legal basis for the application, which is dealt with at paragraph 10 and onwards, of course, predicated on the basis that I'm inviting, first of all, for these witnesses to be put back.
Yes.
Your power comes from section 19, of course, and the extent of the order is to be found in section 19.3. And so it's my submission that you must be concerned with whether it's necessary in the public interest for a restriction order preventing publication of that evidence.
Yes.
And we submit that there is a public interest, clearly, in maintaining the administration of justice and ensuring that there isn't any substantial risk of prejudice to the trial. Paragraph 11 of my document sets out section 4 of the Contempt of Court Act, not because I submit you may make an order under that section, because in fact my submission it doesn't allow you to do so, but because, as I say in my document, it may be that you find it instructive, the approach to that, in how you might consider exercising your powers to make the order under section 19. And that provides for avoiding a substantial risk of prejudice to the administration of justice.
Well, it gives rise to consideration of analogous principles, doesn't it?
Sorry, it gives
rise to consideration of similar principles. We just have the benefit of quite a lot of judicial exposition of section 4.2 when we have no comparable exposition of the operation of section 19.
Yes.
Yeah.
I've had this morning, and as I said, I've looked very briefly at significant authorities set out in skeleton arguments. And it may be that I had a look at Archbold this morning, which is, of course, for me, where one turns in the Crown Court when we come to consider these matters.
Well, at the moment, I'm inclined to think that most of the principles, I wouldn't say all because it's quite a complex area of the law, but one of the best summaries of the principles at play is to be found in the decision of the Court of Appeal in Sarker, isn't it?
Yes, yes.
Because there the Lord Chief Justice summarised the effect of a number of earlier decisions.
Yes.
And explained how one should go about it.
I agree. Can I just draw out a number of, just
Yes.
4 principles? That there is significance in the proximity in timing between the publication and the proceedings. And that's why I make the submission I do, that given that the trial is next week, there is, it's very proximate, particularly if as is inevitable now, the earliest is going to be next week, it's going to be at the same time as the trial. I also have in mind I've drawn your attention to sympathy that might be generated.
I'm still not sure I quite understand this argument. Is it that the jury might feel sympathy for the experiences of Ms. Wahhabi and Mr. Gomez, and what might therefore say to themselves, well, we feel sorry for these people, and so we give their evidence greater credence?
I can't put it in that way.
I'm struggling to find the
Yes.
rational connection,
Yeah.
that's all.
I can't put it in that way because it is inevitable, is it not, that anybody, any reasonable person, is going to feel a significant degree of sympathy for anybody
Yeah,
who was involved in
course.
that. So I can't put it in that way. But what we are at risk of ending up in a situation of is reporting of harrowing detail in relation to a specific witness who I am inviting the jury to, and I will invite the jury to say, this witness is telling you the truth. You can act upon it and be sure that what she's telling you is right. Of course, counsel representing the defendant will wish to say, you shouldn't accept that. And the risk is that because this particular witness is giving evidence here, and if it's widely reported, will attract particular attention, then sympathy might play a part in a way that it should not do so. And I acknowledge that directions are given to juries, that they must not allow themselves to be driven by sympathy, and they must bring
Well,
clinical thought
that's
to it.
usually sympathy for the victim,
Yes.
isn't it?
Yes.
And that's a very immediate consideration. Neither of these witnesses is a victim in the
No,
ordinary
but
sense.
it's inevitable that in a case like this, the judge is going to have to direct the jury, that they mustn't allow
Of course.
that sort of material to influence them. But we all recognise that juries can be influenced. And that is why there is
Yeah.
in existence the power. And so that
No,
is
but my
the
point
real
was really
problem.
this. If judges routinely direct juries that they mustn't be swayed by sympathy for the victim of the crime, who will almost invariably have given evidence about the experience itself, why, and that's not thought to be a problem, why is it a greater problem in a case like this, where the people giving evidence are not the victims of the crime? I mean, they might be described as victims in another sense, but not victims of the crime. So why is it a greater problem in this case?
There's a distinction in my respectful submission, and it's this. One, where you're talking about don't allow yourself to be driven by sympathy in relation to the victim. You're talking about the evidence with which you're dealing before that before that court. Whereas what we're dealing with here is reporting extraneously. Right. So there is a difference in my submission.
Yes, all right. Thank you.
I know it's likely to be said, well, there has been publication, and of course this inquiry rightly has been the subject of continual reporting and interest. But what the authorities also make clear is that the fact that there might have been some risk of prejudice previously doesn't then preclude a finding that this latest publication might create a further substantial risk. And so in my submission, the fact that there has been previous reporting shouldn't affect your decision making. Can I turn to the submissions?
Yes.
It's our submission, and I've said it really, but may I just summarise it? Without restriction, and I do have to start there before I move on.
Well, I think it is a helpful place at which to start, to be
Yeah.
honest, for all sorts of reasons.
Without restriction, given the likelihood of widespread publicity and the proximity of the trial with such publication, there is, in my submission, a substantial risk of prejudice arising in the criminal trial. I should tell you that the defence are very conscious of this inquiry, obviously, being ongoing. I'm not troubled by the fact that the inquiry is ongoing, nor that this inquiry has had evidence before it that touches upon some of the matters in ours. But I venture to suggest that if there is widespread publication of evidence before this inquiry during the course of the trial, that whereas the defence may be put off to a degree making any application because of previous reporting, I venture to suggest there may be an application. I don't know what the judge will rule.
Well, an application of what kind?
That this trial shouldn't go on at this stage because of prejudice.
There are two possible applications that could be made, are there not? Well, there may be others of which I haven't thought, but certainly I can see there might be two. One is just an application to stay the indictment, and that would have to be made right at the outset, wouldn't it?
And that is never going to succeed.
Well, you saved me the trouble of saying it.
Sorry?
You saved me the trouble of saying it.
It isn't going to succeed because the authorities make clear that proceedings should only be stayed as an abuse if there's no other means of resolving the issue that gives rise to the application to stay. And plainly...
Yeah, essentially it goes to the ability to have a fair trial.
Yes. And plainly that can be achieved if there is widespread publication by putting the trial off.
Right. So the only application that you are really concerned about is an application for an adjournment.
Yes.
Okay.
And I have in mind that both of these witnesses, as I understand it, have been supportive of the prosecution, wish the prosecution to take place, and would wish to see this defendant dealt with in the way the Crown seeks to do so. Mm-hmm. So there is an interest for them to get this on. Mm-hmm. And I have seen a victim impact statement which makes clear that having these criminal proceedings waiting in the wings, if you like, has been an added stress to these witnesses. And so that is something that we would wish to avoid in their interest. So if there is any application to stay, we would say no, you can alleviate it by putting the trial off. And it's for that reason that I set out what I do at paragraph 16. May I make clear that I am not inviting you, sir, to assist the Crown in any way with demonstrating we've acted with all due diligence to seek to assist us in extending custody time limits. I am not speculating about what may or may not happen. What I am trying to do is to set out what may be the consequences, because one has to look to see where this can end up. And it seemed to me right that you should be told, and you ought to have in mind, what may happen. But that's not your primary concern, and our primary application is that there is a substantial risk of prejudice, and that's why we make the application. And so, delay the evidence of the witnesses, and failing which, exercise your powers, please, under Section 19 and make the order.
Well, can we just tease out what you say in paragraph 16 a bit?
Yes.
The argument, as I understand it, is essentially that if the witnesses give their evidence in the ordinary course, and it is live streamed as it would ordinarily be, the defendant might be prompted to apply to the judge to adjourn the trial. That would be an application, what, that he'd have to make at the outset, or could that be made at any stage?
I think you can make it at any stage. It may require the discharge of a jury.
I can say you'd have to discharge the jury then, wouldn't?
Yes.
Yeah.
It's not unheard.
So the first question is, the defendant might or might not make that application. Then the question is whether there's a significant risk that the judge might accede to it.
Yes.
Then the question is, when could the trial be refixed? Now, I have no idea what the problems facing listing officers in Isleworth are, and they're probably as great as they are everywhere else.
Yes.
But there would be a reason to bring this case back as soon as possible. As soon as it was safe to do so.
Yes, I was going to say, if the judge has already acceded to the proposition, then it would be difficult to do it.
So the argument then runs, if the judge were to adjourn the trial or put the trial back in one form or another, it might go back beyond the custody time limit.
Yes.
Then the Crown would apply for an extension of the custody time
Yes.
limit. And there's a risk that the judge might say no.
Yes.
But that's a risk which I'm in no real position to evaluate because you've given me no basis for evaluating it. And I don't think you're standing there saying that the CPS or the Crown in some other guise has not been proceeding with due diligence and expeditionary.
I'm not saying that.
So why would the judge not be willing to extend the custody
I
time
don't know
limit?
what the defence might have to say about that.
No, but you know what the facts are about
I
the
know what the
prosecution.
facts are, and I know that it would be my submission that we have acted with all due diligence and expedition. What we may be faced with is the defence saying that this has come about because you, the prosecution, and that involves not just the CPS but the police, because so far as the Crown Court is concerned, we are one. You have not taken steps appropriately to ensure that this situation didn't come about. And the reason that we have now found ourselves in this position of having to make this application to either adjourn this trial or to discharge this jury is because you didn't act appropriately.
Well, now, how can I evaluate the prospects of the judge declining to extend custody time limits when the application is based on what's been going on here for which you're not responsible? I just don't see how I can make an assessment of that.
You can't, and neither do I invite
Well,
you to do so.
Well, you have to, though, don't you? Because it's an integral step in your argument, which we haven't got to the end of yet, but that the judge may decide to adjourn the trial, but may not agree to extend the custody time limits. Well, now, that's a step in the argument that I have to consider, isn't it?
In my respectful submission, you don't need to embark on that. What you need to be concerned with is whether you are satisfied that there is a substantial risk of the trial being prejudiced. All of those other matters are simply to inform you of what consequences might flow. You can't assess and second guess.
Well, just a minute. I mean, the question I think the question I have to ask myself is, will the administration of justice be prejudiced? No. If it were, let's assume it were, if it were clear that the trial could be put off without any adverse consequences of the kind you're suggesting, it would be quite difficult to say that the administration of justice was significantly prejudiced. Your argument, as I understand it, is leading to a conclusion, which is the possibility that the defendant might abscond, and although he could be tried in his absence, would not be amenable to punishment unless he were
No, I don't
caught.
suppose he'll come back.
No, well, sometimes I have personal experience of absconders having been tried in their absence and subsequently caught, but that's a different matter.
Yeah.
But these are the steps in your argument leading to the punchline, which is the defendant might abscond.
That is a possible end result.
Well, it's the only one you're concerned about, isn't it?
Well, no. What I am concerned about is trying to ensure that this trial takes place next week in the interests of the witnesses.
Well, yeah, all right.
That's what I'm concerned about, and that trial should take place without a risk of prejudice to the defendant. That is what I am interested in. What comes thereafter, if that doesn't materialise, is simply to inform you of what may happen. In my submission, what you should be turning your mind to, sir, is whether there is a substantial risk of prejudice arising out of this evidence from this inquiry being widely publicised. Mm-hmm. And if you are satisfied of that, then the next question is what you can and should do to avoid that. And we submit that the best course, although it will cause untold difficulties for timetabling, when you balance, if you come to the conclusion that there is a substantial risk, when you balance the interest of maintaining the administration of justice and maintaining openness, and it's where I began, then the balance falls in favour of the difficulties that will be caused in timetabling.
Well, we're now talking about timetabling on both sides of the equation, aren't we? Because you're now saying your concern is not one of ultimate success or failure of the prosecution going to its trial going to its end, but the timing of the trial.
Well, yes.
I mean, I think it follows from what you've just been saying that you would be making exactly the same argument if the custody time limits for some reason didn't expire until, let's say, end of March next year. So there was obviously time to get the trial back on and completed before they expired.
Yes, I would.
So it's all about timing.
It is. It's about making sure that the trial, as it is about to begin, can take place without any risk of prejudice to the defendant. That's what I'm concerned with, which is why I say, although I set out at paragraph 16 what may happen, that's really just for the sake of completeness.
All right.
And that's why I say, in my respectful submission, although it may cause difficulties, the best course to achieve all the necessary ends is to put these witnesses back until the conclusion of the trial. And if I'm
So do you have a submission to make about the balance between not just inconvenience but disruption and so on to the inquiry and a potential delay to the trial process? And why is the trial more important than the inquiry's programme, which is very carefully constructed, involves a lot of different people giving evidence at certain stages, and might be seriously disrupted if I had to change the order of taking evidence?
I do not, and I want to make absolutely clear, I am not suggesting for one moment that this isn't a most important and significant inquiry, and that there are most significant and important matters that it's turning its attention to. But we are also balanced in that, and we have to keep this in mind, no matter what the Crown's case may be against this defendant. He is at the moment sitting in custody and presumed innocent. And until such time as that jury returns a verdict as to his guilt, he retains that.
Yes.
And as difficult as it is, I come to this as prosecution counsel in a trial where a man risks losing his liberty for a considerable period of time. Thus far, the defendants who have been sentenced have pleaded guilty. The factual matrix of each of those cases, as I understand them, have been much less serious than this one. And sentences, I think the lowest one I saw was some 3.5 years on a plea.
Yes.
I anticipate this defendant, were he convicted, to get a considerably longer period than that. And certainly any document I submit to the court will deal with that in that way. So it's a difficult submission I've just made, but it's one I feel I must.
Yes, all right, thank you.
If you don't find favour for the reasons that you've just said, then we submit you can and you should exercise your powers under Section 19. I know that looking at the transcript from Wednesday, there was some concern about how it can be framed because of the nature of publications as they appear now, because we're not talking about just press and television. We all know that people tweet, people blog, people engage in all sorts of social media. But in my submission, publication in any form, and I note the wide definition of publication in the Contempt of Court Act, that you could properly say publication in any form, and that would cover everything. And we submit it would be a proportionate response to restrict, if you're not with me, that the witnesses should be moved, to restrict to a very limited period of time, which would be the conclusion of the trial. Now, just looking at this, I have on my witness order to call both these witnesses on Monday. I anticipate, therefore, that the earliest they could come before this inquiry would be Tuesday. I anticipate, all going well, that we will have verdicts from the jury by Thursday, and if not Friday. And so really what I'm inviting is a restriction order if you feel you must go that way, as opposed to putting the witnesses back for a period of, some 72 hours. And of course, whilst they're giving their evidence.
And you would be content, would you, for the reporting of their evidence to be permitted after they've given their evidence and before the jury has given a verdict?
No, that's why I'm saying until the conclusion of the
well,
trial.
Well, exactly. You see,
yes.
And in fact, what you're asking me to do is to restrict publication of their evidence until there is a verdict, whenever that may be.
Well, I anticipate, given the length of the time.
Well, you're assuming no hitches in the trial.
Yes.
I am.
You're also assuming that the jury doesn't have to be discharged for some other reason, completely extraneous to this, and which has been known to happen. And you're also assuming the jury can agree, which again sometimes doesn't happen.
If the jury has to be discharged and the trial has to go off, then we will be in the situation where we can put it in at a time after a reasonable period of time after they've given evidence here.
Within the custody time limit, or you're still going to have to extend that?
Well, no, because once the trial begins and the jury has to be discharged, then the custody time limits don't apply in the same way.
Of course, you're right.
So we won't have that problem then. And then if a jury can't reach a verdict and there has to be a retrial and the Crown decides that that's what it seeks to do, then again we can fix a trial at a time which we would submit. Any prejudice that might be can be alleviated by the passage of time. Yeah. Because as I said, I don't say that the reporting of this inquiry throughout the time it's been running is such that there is prejudice. It's the proximity of these particular witnesses at the time of the trial which brings us here.
Well, it may be because we had to stand down Mrs. Wahhabi on Wednesday.
Yes.
We've now got to find another date at which she can give evidence, and I don't at the moment know quite when that will be, and so I can't say for certain when we're going to hear from either her or Mr. Gomez. So we may find it all happened after the event, but that's not the point at the moment. The question is the one
because I don't know the answer.
Quite, the question is the one of principle.
Can I assist you any further at this stage?
No, I think I now understand better than I did the nature of your application. Thank you very much.
Thank you, sir.
All right. Oh, do you want to say anything about the case of Sarker?
I don't.
I've looked at it. I think I understand what it says, but if there's anything you need to say about it, now's the time.
No, I don't.
All right. Thank you very much. There's one other thing you can help me with. When the matter was before me on Wednesday, Miss Clark asked that I give my reasons for the decision in writing. I imagine you'd write like that as well, would you?
I don't press it in the same way. I rather suspect what may have got lost in translation was I said that I was looking for some help to try and get this case fixed. And I said if Mr. Chairman has anything to say about that, then that would help us. Because I'm afraid what happened, for reasons I still don't understand, again, I'm not going to examine it here, the case went into a warned list and not into a fixture. And so we've been trying to get it fixed. We did manage to do that on Wednesday, which is why I was able to then ring and pass the message through that it is fixed for Monday.
All right. Well, thank you very much. I'd like to thank all those who provided skeleton arguments, perhaps not entirely skeletal in some cases, but at least observations, submissions in relation to the application. I've read them all. I found them helpful and interesting. I and I don't need to trouble any of you because I'm afraid I've reached the conclusion, Ms. Felix, that it would not be right for me to make reporting restrictions in this case, nor do I think it would be right for me to direct that these witnesses should not give their evidence before the jury's verdict is delivered, even though, although it may be that in practice that may not happen in any event for reasons of the administration of the inquiry. So I'm afraid I'm not going to give you the relief you're seeking, and I'll give my reasons in writing as soon as I can, I hope on Monday.
Thank you, sir.
All right? Thank you for your assistance. Right, is there anything else that needs to be dealt with? Mr. Millett?
No, Mr. Chairman, not on this present application.
Well, I think there is actually, and I should have thought of this and I should have invited your help on this. At the moment, this application is being conducted under reporting restrictions. It occurred to me that, and it may have occurred to you, that you would wish those restrictions at least to be maintained until the early part of next week, because it would be unfortunate if anything said here, when reported, put ideas into the mind of the defendant.
Yes.
So, subject to hearing anyone who wishes to oppose what I'm now going to propose, I'm minded to direct that the reporting restrictions currently in place should continue until further order. I would envisage lifting them, I think, as soon as the defendant has been put in charge of the jury, though I'll hear you if you want to address me on that. Because at that point, the trial will be underway. The trial will have started for the purposes of custody time limits. Any application, however ill-advised, to stay the indictment will have been made, and the proceedings will be running along.
Insofar as the defendant is concerned, and I'm thinking on my feet here, I'm considering my disclosure obligations, and I haven't given it thought. But I will need to reflect on whether we must disclose that this application has been made, the submissions that have been made, and that may, in and of itself, I don't know, result in applications. I just don't know what the defendant might do.
Well,
So,
yeah,
but
go on.
I do invite you to keep the restriction in place because reporting of it may give rise to problems in the trial.
Yeah, all right.
And so I'd ask, in fact, for that restriction to continue until the conclusion of the trial.
Well, what I'm inclined to do is to say it shall continue until further order, but, and that I may allow it to run until the end of the trial, but I think it's important that I be kept closely informed of the course of the trial.
And we shall do that.
Please, so that I can consider, if necessary, of my own motion, whether the restriction should be lifted. The press themselves, who are present by counsel, are clearly interested in having them lifted as soon as possible.
Yes.
And if they want to address me now, I'll hear them. But they may wish to come back to me during the course of next week to argue that the time has come in any event. Now, Mr. Friedman, you looked as though you wanted to make a submission.
I think I've set it out in our skeleton at paragraph 19, but we agree with the proposal you've just made. But I wanted to draw a distinction between that limited reporting restriction order until further notice and the situation of this hearing, which is a private hearing, which has at least two implications. One, what we as RLRs are allowed to discuss with the CPs. And secondly, it has implications for open justice in Section 18 under the Inquiries Act. Mm-hmm. And my respectful submission remains the same as when I last addressed you, which is the norm in this kind of situation. And there can be very common, these kind of applications, at least in Crown courts,
Yep.
dealing with extraordinarily prejudicial matters relating to the trial in front of the jury, where a judge will make an order like the one you've just proposed, but all of this would have gone on in public. Now, we can't rewrite the book. I'm not suggesting necessarily that we need to release the transcripts that are available today, but I see no reason, if I may put it this way, why the responsible advocates in here cannot explain to their respective clients what has gone on, advising them and making clear, as you will do, that there is an order about any further publication within that sense. Mm-hmm. I also respectfully say, not because I've got a brief to do so, but I see no reason why all other RLRs of all other CPs should not have their own access to the transcript of these proceedings, simply to make sure everybody is aware of what's gone on, because of course we're interested about the subject matter of this application, but it does have wider implications for how you approach
well, it does.
the open justice, doesn't it?
I entirely accept that. The difficulty that I see is that reporting of this application and the submissions that have been made and so on might have adverse consequences for the trial,
Yes.
which ought not to occur and which are less likely to occur if these proceedings are not reported for a limited period. Although they're part of the inquiry, they're not an integral part of the inquiry's work. They're an ancillary matter. Yeah. And it seems to me that on balance, it's better to keep things as they are for a short time.
Yes.
We can discuss, maybe on another occasion, how far information about this application can be shared with your clients.
Yes.
It's important that your clients understand that it's not to be disseminated. But I nearly said you can make me an offer, but what I mean is you can put forward a suggestion.
Yes.
As to how that can be framed, and I'll certainly
I understand, and we'll give it some thought. And can I say, I don't disagree with anything you've just said, sir, save to say that in our respectful submission, that would not be good enough, because there is always the possibility of people disregarding orders, and I wouldn't want, even if this is an ancillary matter, for particularly the core participants to have any sense that ab initio, or by some default position, they can't be trusted to comply with orders. And I take the point that this is a short time, but I hope you don't feel it's remiss that I have said that, not least because actually a lot of people are coming up to us and saying, you know, some of them are saying, we know fine well that there's a prosecution at Isleworth next week. And I said that to you last week because I've been approached by my clients who are related to this family. But secondly, it unsteadies the nerves, and you know why. And we've worked so hard, particularly in the last few weeks, to crystallise a kind of quality of engagement with the inquiry. And so I just ask you to bear that in mind, and perhaps we'll move on this and think about it again.
All right.
But thank you.
Well, thank you very much. Now, Mr. de Wilde, you're here for the press. You've heard what's been said. Insofar as you're opposing the substantive application, I don't need to trouble you.
No.
Do you want to say anything about the point I've just been discussing?
I respectfully agree with...
Yes, find a spare. Sorry.
I respectfully agree with Mr. Friedman's analysis to the extent that there is a distinction to be drawn between privacy applying to this hearing and a reporting restriction order protecting the interests engaged at the criminal proceedings, which you've heard submissions about this morning. It was an issue of slight concern to us that our lay client, our journalist client, wasn't allowed into this hearing on the basis that it was private.
Well, no, you say your client. A representative, the only representative of the press who was present when the application was made on very short notice was here and was allowed to address me. She didn't have very much to say for obvious reasons, but the press were invited to make submissions.
Yes.
And of course, I'm grateful for the fact that you've come here again at quite short notice to represent the interests of the press.
In my submission, it's simply illustrative of the fact that there is no need to exclude journalists generally from this hearing, or for it to be in private, where there is a reporting restriction order in place which prevents reporting of it. As Mr. Freedman has eloquently explained, these types of applications are typically heard in open court. The fact that they're not in private does not mean that reporting and resulting prejudice ensues from them.
Well, the distinction between public and private and reporting restrictions and unrestricted reporting it may be a bit more nuanced in the context of an inquiry, because Section 19 contemplates either excluding evidence from being disclosed to the public or excluding the public from the hearing. So it's slightly crosses the boundary. But anyway, we are where we are. I made an order on Wednesday as to the conduct of the proceedings then. I'm not minded to change that now, but I am very concerned to ensure that the restrictions are not enforced for any longer than is necessary.
Yes, well, we've heard what you've said about that, and we're very grateful for those observations, yes.
All right, well, thank you very much. Now, you've heard all those exchanges. Is there anything you want to say about duration of restrictions or anything?
Only what I've already said.
All right. Well, I'd be grateful if you could keep us closely informed
I
about
will
the
do that.
course of the trial, and we'll see where things go. All right. I'll say it again, thank you very much, all of you, for your submissions, which I found very helpful. I think that's all for the day. Thank you.